My lord, the petitioners were initially appointed in the year 2002-3, my lord, as a Panchayat Shiksha Mitra. Thereafter, your lordship, the new rules had come 2006, where they were taken up as Panchayat teachers. They were supposed to have been absorbed. But my lord, before the absorption could take place, my lord, they were not. They were removed from the service on the ground that now better qualification is now required, my lord. They were initially appointed on the matriculation qualification, my lord, eligibility criteria. Thereafter, the state government, my lord, changed the rules, and after that it became intermediate, my lord, 2005. But no opportunity was granted at that time to better their degrees. So a series of litigation had come to the High Court, and the High Court had said that this action of the government cannot be punitive in nature, my lord. Thereafter, the opportunity was granted that within 33 months you have to complete your degree, my lord, and they'll be considered to have been absorbed. My lord, thereafter also there were several litigations, my lord, in which one of the judgment in 2010, the Honorable Court has said that even if they have acquired qualification thereafter, still they would be considered to be continuing on their post, and benefit of absorption will be granted, my lord. In the 2006 rules.
When did you acquire the qualification?
My lord, that I acquired in the year 2014, my lord. Annexure 7.
Then, so from 2005 you were out?
My lord, after that we were out, my lord. After that, because of the litigation that were pending before the court.
Might be, but you were not part of that litigation.
No, my lord. We were not part of that litigation, my lord. There is some delay there, but I am
not delay. You are out of the job for last how many years?
Well, I have yes, my lord. At that point in time, about 7.
You have to be. The condition was those who are working as on 1/7/2006.
Yes, my lord. 1/7/2006 was the cutoff date.
Those who were working.
My lord.
You were not working.
I was not working, my lord, but thereafter, my lord, in 2010, the Honorable Court had held a coordinate bench that even if they were not working, my lord, they will be considered deemed to have been working, my lord, and then that benefit of absorption will be.
Might be for those particular persons.
My lord, I have that judgment in the court. 2010, volume 2, page PLJR, page 241.
Yes, what does it say?
My lord.
Yes, you read it out. What do you want to see?
My lord. 241. Paragraph 7 and 8, my lord, at page 242. On consideration of the statements made by the counsel for the parties and their pleadings, I find that division bench had passed order in LPA in absence of counsel for the appellant. Government circular dated 21/4/2005 was relied on holding that within 33 months time, Panchayat Shiksha Mitra should obtain intermediate degree, but in fact, in the said government circular, there is no such provision. Petitioner took up equivalent intermediate course in the sessions 2003-5, which could have been completed prior to 6/2/2006 if the examination could have been held in time. The government circular dated 4/7/8, being an executive order, should not have been made retrospective, since it is well settled that no executive order direction can be made effective retrospective.
Come to the facts of the case.
Madam.
Petitioner's first engagement was renewed on 25th March 2004.
Yes, madam.
Again on 6/5/2005, and then 6/4/2006. So she has continuously, and she was again re-engaged on 29/6/2007. So she continued to work.
Yes, madam. In here, that she had continued to work.
Each case is on its own facts.
Yes, that is true, madam.
Okay. Petitioner admittedly was disengaged after having worked for 11 months as a Shiksha Mitra.
I was granted one extension, my lord.
The qualifications required for continuing to the Shiksha Mitra were enhanced to senior secondary.
Intermediate, yes, madam.
Intermediate, which the petitioner did not possess. And he remained, and they remained unemployed till stop. The petitioners have thereafter acquired qualification of inter pass in the year 2014.
Madam.
And claim that they should be de-engaged as Shikshamitra and deemed to be continuing from the date their services were dispensed with. As in the original terms of employment, there was no such condition of acquiring enhanced qualification. Learned Counsel submits that in a similar case reported in 2010, Volume 2,
PLJR.
PLJR, Indu Devi versus State of Bihar, this court has allowed similarly situated person to be deemed to be continued as on 1/7/2006 and also directed for reinstatement. I have considered the submission, find the facts of CWJC, facts of the aforesaid case Indu Devi versus State of Bihar as different from the present case. The said Indu Devi was appointed for 11 months on 7/3/2003. Her engagement was renewed on 25/3/2004 and then again on 6/5/2005. And again she was re-engaged on 29/6/2007. And while she was holding the post of Shikshamitra, she enhanced her qualification of intermediate on 11/8/2004. कब किया इसने?
3-5 session में 2003-2005 session में she had completed it.
Complete on 20th September 2006. The result was for the session 2003-2005. In the said facts and circumstances, distinguishing an earlier judgment passed by this court, relief was granted to her. The said judgment is in personam and would not have an application to all the cases where Shikshamitra services were dispensed with on account of not having the requisite enhanced qualification of intermediate. Writ petition of the petitioner being on different facts is not similar. On merits, this court finds that the petitioner acquired the qualification in 2014 and after 1/7/2006, post of Shikshamitra itself was abolished and post of block teacher was brought into existence and new rules were framed governing such teachers. In the circumstances, the petitioner has no case for retrospective appointment. The petition is dismissed.